All right, we are back in Senate Judiciary. It's still February 26th, and we are still on S-193. We're coming back from a short break, and we have Karen Barber here with us.
Good morning. For the record, Karen Barber, I'm General Counsel of the Department of Mental Health. Apologies for not being in person. My kiddos are on break this week. I had some things prepared, but there's been a lot of discussion, so I'm going to try to reorganize my thoughts. So if I haven't addressed any of your questions, please let me know. But I guess maybe I'll start off with some of the general questions that you've had, and then I can dive into the language a bit if that works. One of the things I just wanted to highlight was that just like now, if someone at any point of their incarceration needs involuntary mental health care, they already do get that. There already is that process in place, and this language would continue to allow for that. DMH has worked to train DOC staff to be what we call qualified mental health practitioners. And so that those are the folks designated by DMH to do the first certification, which is the first step of the involuntary process. So we do regularly already have folks that are in DOC custody that decompensate and need mental health care. And so we already have a seamless process. There's also an MOU we have with DOC. So we're already doing that process. So I just wanted to assure the committee that that is happening and that will continue to happen. Let's see, qualifying condition language. We support the language. The original language we didn't we had concerns with, one, because it was making it just about mental illness, and we've worked really hard to talk about why this isn't just about mental illness. And we do agree with Susan that those are terms that we don't use. Qualifying condition to us is doesn't have any connotations. So happy to continue to talk about it in the policy committees if there's a concern, but from our perspective, that language makes sense and is appropriate. Did you have
Any questions on that piece of it? Sounds good.
Okay. For the records, so there are already ways within HIPAA to share records that are relevant for continuity of care. And courts also routinely issue orders to ensure our forensic evaluators get access to records. So, I'm not sure that there is a need to add language. However, we don't necessarily object to the language as written. I do think that there are times where there are records that are not actually necessarily needed to provide care that someone may not want to share. But if there are records that are relevant to providing care, there are already mechanisms to get those records.
Which language are you looking at specifically?
Oh, the new language you added around records in response to Dr. Robbins' testimony. Apologies. Let's see. That's page
11. Yeah, I just want to make sure we're looking at the same.
Yes, apologies. Yeah.
So you're going to buy me again. What were your thoughts on that piece?
So from our perspective, there's already exceptions under HIPAA that allow for sharing of information due to continuity of care. So if there are medical records that providers actually need to provide care, we are able to get those. We also see that courts routinely issue orders that said, like, our forensic evaluators can get access to records. So I'm not sure that we need this language, but we also don't object to the language if it's something that people feel is necessary. I didn't completely understand the testimony, but I also didn't kind of have enough time to really think through what Dr. was saying. I do think there are circumstances sometimes where there are different evaluations or things out there that clinicians may want because they think it would be helpful, but it's not actually needed to provide care. And I think that gets to the concern around people making decisions about what they want to share, to Katie's point.
All right, so you don't really have a position one way or the other on the language that's on page 11? Okay.
Yeah.
And I am noting that I think this is something that this would fall under health and welfare's purview a bit more so than ours. So just send that along to them as well. Okay, thank you.
I also just wanted to kind of as a general requirement, um, all of AHS is looking, well, except for DOC, but most, we're looking at least restrictive environments already. So I know to Susan's point, and you've had some conversation, um, we do already kind of consider least restrictive alternatives, and that was something that was tried to be baked into the language. And I can kind of talk about, I see where maybe some of our language didn't completely translate, and so the goal was never to like hold someone indefinitely and never consider least restrictive alternatives.
Senator Vosky has a question about that.
I do have a question about that, and I appreciate that the Department of Mental Health already looks at least restrictive settings, but I don't know that DOC does. And so I do think if that is a concern of mine. I don't know that
And we don't object to language that kind of, if you don't feel that that's clear, we wouldn't object to language. I think to your point earlier, and to the chair's point, the language is really meant to say if there's a treatment concern and that's connected to a public safety concern. So if there's not that, if you can't meet the burden of showing there's that public safety concern, then they wouldn't be appropriate for the facility, which would mean they would be in a less restrictive level of care. But if you feel that it needs to be more fleshed out, we don't object to that. The idea is not to just lock people up and throw away the key, right? The idea is to really be very focused in a small group of individuals where there are real treatment and public safety concerns. And that's the gap we're trying to fill. So for the language, I had a couple of thoughts, but then I know that there were some new things that came up. So I wanted to try to make sure I was addressing all of your concerns. In terms, so there was a lot of talk around the competency restoration piece and what would happen if they couldn't be restored. We have always said, right, that there will be some individuals that probably can't be restored. I think it's probably a small number. We're also talking about a really small number to start with, but that is why we felt like there should be some language in there around that. I think when we had originally proposed language and then it got tweaked in this draft, I think what our idea was that is if they couldn't be restored, be a to found NGRI. Right? So there would be an option for the.
Sorry, you're.
Oh, I'm sorry. Can you hear me now?
Helpful. It might be helpful for your internet bandwidth if you turn off the video and because you're cutting in and out and we're not able to hear what you're saying.
Oh. There we go. Okay. Are you okay if I'm off video?
Yeah, that's fine.
Okay. Can you hear me now?
Yes.
Okay. Our goal with when people were found not competent or that when they couldn't be restored, if we determined that they couldn't be restored, was that there would be a process similar to those found not guilty by reason of insanity, meaning that if there were treatment needs that connected to public safety concerns, that there was an option for them to remain in the facility. However, if they could be maintained in a less restrictive environment, that made sense. And there's language already in the NGRI section on page 8, at the bottom of page 8, where it talks about if the reviewing court finds that the person is no longer suffering from a qualifying condition that upon the person's release would create substantial risk. And then it allows for a conditional release with an order with conditions. And so our idea was that that process would also be available to folks who were found who couldn't be restored to competency, because the idea again is that we're addressing the gap where there are folks that there's not a secure setting available, but there's also not a way to kind of impose conditions focused on public safety on them. And so if they really don't meet, if they're not dangerous enough to public safety to remain in the forensic facility, if the court makes that determination, that there's still an option to put conditions on them that are enforceable.
So just so I understand, you're recommending that the language that starts at the bottom of page 8 and goes on to page 9, that essentially be copied onto the section that talks about what happens if a person is not competent and they're not likely to be restored to competency?
Yes. And if you look at the language, it talks about, let me go back up. It talks about the person could be, sorry, I'm trying to find the language. It talks about a subsection 2. And I think when we originally were working on the language, we meant that subsection 2 of that section. And I think that's what wasn't translated. So if you see, okay, so on page 2, it talks about if the court finds that the person can't be restored, the person shall be subject to commitment pursuant to this subsection 2. What I think, and I apologize, I should have caught this earlier. When we were suggesting that language, what we meant was that subsection 2 of that other statutory provision. We meant to link the two, and I missed that, so I apologize. But that was our original intent.
Got it. Okay.
Does that make sense?
That does make a whole lot more sense than the rabbit hole I was going into earlier. Let me just, in 1 second here to make a note. Committee, how do we feel about having what we see on page 8 and 9 applicable to what we see on page 2 regarding the people who are not competent and not likely to be restored to competency?
That sort of closes the gap that I was worried about, I think, because it links back in that substantial. So I actually, I don't know. Now I'm confused because page 2 is dealing with a different thing.
Page 2 is talking about
Hold on, I'm trying.
Whether, starting on line 10, the court finds that the person cannot be restored.
Okay, yes, so adding in that aspect that's on 8 and 9,
Yeah.
I think that does close the loop
Yes.
that I was concerned about, so I would be supportive of that.
And I think it is far more clear than what I was trying to propose earlier. Any other folks opposed to tying in that language, which was the original intent from PMH anyways? Eric, by any chance, did you catch that?
Yeah, yes, I think I have it.
Okay, fantastic.
Yep.
Great, glad that was okay, thank you, Karen.
Yeah.
Feel free to carry on.
Okay, great. My next comments were starting on page 4, line 3. So I know you guys had a lot of conversation about it just now, and so I wanted to kind of just go back and try to reframe what we were trying to do here. So our concern is that there be a way. So what we see now is that if someone is restored to competency or is competent and then becomes incompetent, that there's kind of this cycle, right? Because trial can't commence unless someone is competent. We also have seen situations where someone maybe has gone through trial and then there's a question of competency before sentencing. And so what we were trying to do was create kind of a seamless path where wherever they were, whether they were being held without bail and already in corrections or out in the community, that if the defense or court raised an issue about competency, that there was a quick way to get that assessed and restoration services if necessary. Even if they were in DOC, I was concerned that there wasn't a way for DOC to kind of like move them to the forensic facility to get these assessments and start restoration without language. And so that's what we were trying to do there. just to clarify, because I think there were some questions about that.
One question I do have on this is if there should be additional language that would allow for a return to a less restrictive environment to get competency restoration. And the reason that I'm suggesting that is if somebody's had their competency restored and they're released because they're no longer a substantial risk to the public, would it make sense to send them back to the forensic facility / correctional facility where there's challenges in terms of staffing and the number of people who are there? Could it be more helpful to have that person sent to a psychiatric hospital or some other place where they could get returned, where their competency could be restored that isn't DOC?
So potentially, but I don't know if someone actually meant hospital level of care, then they would just go there and you wouldn't need to add extra language. That wouldn't be an alternative unless they actually met the criteria, right, laid out in statute. And so that's already, I would say, in there because a threshold to go to the forensic facility is that they're not a person in need of treatment. So from my perspective, if the feeling is, and again, they would also have to, I think, there would be a burden to show that they would need to be in a locked facility, right? But there's no other alternative. If they don't meet DMH criteria to be in our hospital, there is no other secure environment. I think there could be a way to say, consider if there are less restrictive alternatives available. I think the goal is to just make sure that if competency is raised, that there's a way to kind of quickly assess that and then provide services if necessary. Because the longer, the longer you wait, the longer trials get backed up. And so I think the idea is that we're not kind of contributing to that.
And I get what you're saying now. Because let's say they get released and they weren't considered a substantial risk, but in order to go back, they would need to once again become a substantial risk. So I get it. Okay, that makes sense. Committee, any questions at this moment? Okay.
So we support that language. The only thing I wanted to raise is that, we've worked hard in the proposals that we've submitted to you to work with the state's attorney. Jared is on vacation this week, and I would just want him to weigh in on the piece around it being the state's attorney's burden, just because elsewhere in statute, it's very clear that it's the defendant's burden, that the defendant is presumed competent, and that they have the burden of showing they're not. And I get, Eric and I talked about this last night, I get what he's doing because he's trying to mimic the language that's in the not guilty by reason of insanity section. This may be a little different though, right? Because I think the state's attorney is never going to probably be arguing that they're not competent. It's generally, right, we see the defense or the court raise concerns about competency. And so I'm just highlighting that as, criminal law is not my thing. I don't know exactly how to thread that needle, but I'm just flagging it as a potential. I can see that being a concern of the state's attorney, and would just want to make sure they or the AGO can weigh in on that piece. Does that make sense?
I think, the way I envisioned the language, look, if we're talking about page 7, we're on page 7, right?
Page 4.
Okay, so you're just referring to that section. One second.
Yeah, page 4, starting on line 11, the commissioner shall notify upon readmission, the court shall hold a hearing where the state's attorney shall have the burden of establishing by a preponderance of the evidence that the person is not competent. I think that's the defendant's burden, but I can see that the state's attorney could have the burden of showing that they needed to be in the forensic facility.
I think the idea is getting at, this person's been released, they're competent, but they lose competency, and now the state wants to return them to a locked and secured facility, which would curtail their liberty interest.
Yep.
And so it would be the responsibility of the state to say, we have this new evidence that this person is no longer competent and there's a substantial risk. So here's that evidence. We need to bring them back to DOC. That's how I'm envisioning it in my brain.
Yes, which makes sense. I think it's just maybe right now it just says that the person is not competent. And again, maybe I'm overthinking this because it's the state's attorney. I just wanted to make sure that they had an opportunity to weigh in on that if they had concerns about it. I think we're saying the same thing, like the goal of it. I just want to make sure they're okay with that language. And I don't feel like I can talk on their behalf for that.
Thank you.
The only other language that I had wanted to touch on was you may have already resolved. We had some concerns with on page 12, line 5, where it was calling out the Commissioner of Mental Health and wanted it again to be the Agency of Human Services. So it sounds like that may be a decision the committee's already made, but I just wanted to raise it because again, this isn't just DMH, it's all of AHS. And, we already work together really closely. I get why this language is in there, but I do just want to make sure it's agency-wide, not just specific departments.
Senator Bohosky?
Yeah, I guess I know that AHS, I believe it's our largest state agency and covers a whole lot. In my other committee, I'm putting on my government operations hat for a minute, we've heard from the agency and that the different aspects of that agency do work in their silos. And if this is, as we're claiming, a treatment facility, I guess I'm concerned why it wouldn't, I guess I'm confused why it wouldn't be the Department of Mental Health providing that consultation.
Sure. So a couple of reasons. One, this isn't just about mental health. So everyone in there is they're not under our custody. We don't provide mental health and corrections. They have contractors that do that. Dale has folks that they need to and already do work with, same with VDH for SUD. So the reason we wouldn't, just like someone wouldn't, another department wouldn't kind of micromanage how we run VPCH. It would be problematic for us to try to micromanage how DOC runs their facilities. That doesn't mean that we don't consult or talk about. We have, I think DMH has at least, bi-weekly meetings with DOC to talk about folks. Dale has maybe a little less, maybe weekly or something like that. But we are already doing those. Again, we already have some MOUs to talk about how different departments work with DOC. So of course there absolutely should be consultation. We're not trying to say there shouldn't be, but it is not just mental health, it's all of the departments. And we just want to be clear that it wouldn't be us micromanaging or providing services in the facility, but really we are a resource based on our expertise. Our clinicians, health clinicians around substance use, Dale's clinicians around the folks under that they provide services for. So it's really about providing information, connections, how do we all work together versus actually providing services in facilities or overseeing specific work of staff or contractors.
Okay. I appreciate that. I think if it's a treatment facility, it should be, you used the word micromanaged, but I think I would just use the word managed by our treatment providers, but I think that is a continued point of disagreement.
Yeah, I would say it's similar to, so we run, one hospital and one secure residential, but we have folks under our care and custody that are at lots of hospitals and residentials across the state, and we don't oversee that treatment. We, have requirements and we work with them, but we don't provide treatment. Brattleboro Retreat, for the folks that are there, Brattleboro Retreat provides that treatment. So I see it similar to that. The department can't oversee everything, but we certainly do have things that we look at. We get critical incidents reports, and we get various reports. So we're always overseeing quality and looking at things across the system, but we are not, we only provide care at two very specific places, and those are the only two places that we're actually kind of in the weeds about how care is provided, but everywhere else, people are managing their own care provision.
Thanks.
So just to clarify, Karen, did you have any language recommendations for that lines 5 through 7, or?
I had sent but I also just think, if you want it to just say AHS, I think one of the things we thought might make sense was if it just said the Commissioner of Corrections shall consult with other agency of human services departments as necessary when performing the duties as required. That would be my recommendation, but I also would be okay with just changing it to the agency of human services if that's what people felt was necessary. I think to one of the questions, I guess I'm wondering what you want from the language. It's a little unclear for me. And you talk about consulting, but to what end? And so I think that's part of what I was trying to capture in the language, which is that we do consult when we need to.
I think and I'm happy to be corrected if I'm wrong here, I think based on our initial conversations about the bill, our initial hearings about the bill, and the concerns about how much of this is focused on treatment versus how much of this is focused on keeping a person in a locked and secure facility, and trying to make sure that it's not just about putting somebody in a forensic facility / correctional facility, and making sure that there is that focus on treatment and competence, restoration, and so on. I think that is what this is trying to get at, even though, as I'm understanding, DOC is going to consult with DMH anyways on this. I'm fine with just saying that all of this is going to be under the Agency of Human Services, because DOC itself is under the Agency of Human Services. So I guess it's almost a matter of semantics, essentially. But that's what I think is the synopsis of all this.
That makes sense to me.
Great. Committee, or actually, Karen, do you have anything further?
No. I just wanted to be available if you had any questions. I had been listening to different testimony this week, Susan Aronoff and Jack. So if there were specific questions or things you wanted me to address based on some of their issues, I'm happy to. Just whatever you need, I'm available.
Yeah, no, thank you very much. This was helpful, and I think you helped us answer the issue that took up a lot of time earlier on regarding that rabbit hole that we went down earlier regarding when a person is not competent and not likely to be restored to competency, I believe. So that was helpful. And so I think, well, committee, do you folks have any questions or comments for Karen? No? Okay, thank you, Karen. Appreciate it.
Yes, of course.
Eric, I see, did you have any follow-up?
Yeah, I wasn't sure where, thank you, Eric Fitzpatrick, Legislative Council. I wasn't sure where the committee landed in terms of this Agency of Human Services, corrections, mental health language. I know you mentioned, well, we'll just mention Agency of Human Services. I'm not sure what that would then say, if anything.
Yeah, I mean, if it's, well, yeah, if we're talking about lines 5 through 7 on page 12.
Exactly.
Commissioner of Corrections shall regularly consult with the Commissioner of Mental Health. I mean, I don't know, well, committee, what do you want to do with that language?
I heard Karen suggest the possibility of Department of Corrections or Commissioner shall consult with other Agency of Human Services departments as necessary. So that's one option.
try and assert that this is a treatment facility, but it certainly doesn't allay my concerns that it's still just a jail.
I assume there would be consultation anyway, so if we mention it, for me, the key was that they would consult more than once, that there would be an ongoing consultation. But if they're within the same agency, does it do a lot to say that they need to consult with other parts of that agency?
I'm just keeping it, really. I don't think it really.
Yeah, I don't think it hurts.
Yeah, Eric, I think we're just gonna leave it as it is, regularly consult. I mean, I don't think it's going to make a difference one way or the other.
Okay, and did you want to regularly consult with other AHS departments as that sort of thing, or just leave it to DMH?
I think DMH is fine. I don't see any.
Okay. Sounds good. That was my only question. Thanks.
And, okay, all right, yeah, I think that covers everything, more or less. Actually, Eric, one last question for you. Do we, still there?
Yep.
Are you aware of any other decision points that we need to make? Because we covered clear and convincing, we covered the burden, we covered
Prejudice.
with or without prejudice, and I don't have any other decision points listed on the notes that I have in front of me, but was there anything else that, based on what you've heard, is still pending?
No, I don't think so. I think because also you heard from Karen about and we're going to take that different track the approach regarding a person being found not able to be restored to competency. We're going to track that procedure based on the procedure. They could be released into the community, least restrictive means, that kind of thing. So I know where that's going. So no, I'm not aware of anything else that wasn't covered this morning that's still hanging around out there.
Committee, are you aware of any other pending questions? All right, so I think we are in a place where we're, knock on wood, almost done with this bill. We'll get some additional testimony based on what is the tentative final version that we get back from Eric once we return. And then health and welfare, as well as institutions, are going to be taking a look at this as well.
I do want to hear from WellPath. I have pretty significant concerns. There's currently over 1,500 pending lawsuits against them for their inability to provide adequate mental health care. So I have some pretty significant concerns. And
Are there lawsuits pending for their competency restoration?
I mean, I don't know. I haven't looked at all of the more than 1,500 lawsuits. I don't know what every one of them is for. But I know Massachusetts has stopped using WellPath for all of their services, forensic competency, prisons, because they are under a congressional investigation by Senator Elizabeth Warren. Like, I am pretty concerned. And I don't feel comfortable moving forward given that the research I did yesterday has without hearing from them how they're addressing those issues.
Yeah. Okay. We can hear from them. I do think the specifics of the treatment and whether or not the specifics of the treatment is something I think that would fall within health and welfare. But I think that if we're trying to make sure that this is focused on competency restoration, we should still hear from them. But I mean, I did ask for their contact information, I think, a week ago, and at least as of yesterday, hadn't heard, or our committee assistant hadn't heard. help us get WellPath in here, please?
Yes, we've already been in communication with DOC this morning. I heard you earlier say you want it, so we are working with them to get them to contact you as soon as possible.
Fantastic, thank you very much. Yeah, so WellPath will be one of the folks that we hear from. We'll also get testimony from the state's attorney based on the new version that we get from Eric. Wondering if there is anybody we haven't heard from that needs to be.
No, I appreciate the fact that you have asked them to come in. I just, after finding more information, and we've heard a couple of times that they're providing this care in Massachusetts, but that is no longer true because of how poorly they were doing it.
Okay. Well, thank you again, Karen, Eric, everybody. A little bit of input
Thank you.
in this long process. And, oh, sorry.
Just one quick note. I know you're aware of crossover for us. If we have two other committees that are going to weigh in, they're going to have lots of priorities that they want to get over the line. So I wouldn't want them. They should know that they have to get back to us really quickly.
Yeah. I mean, they're aware and have been that I would like them to look at this bill. My thought is not necessarily to have this go into their jurisdiction where they never have possession of the bill. If they feel something catastrophic is happening and they need possession of it, then that's
Yeah, at this point, that would probably delay it.
Yes.
So,
ideally, I would like to get this voted out Tuesday or Wednesday when we get back from town meeting. And that's that. Let's shift gears significantly to, let's see. Eric, you're on S 186 and 183, right? You're muted.
186, yes. I didn't know. What's the other one you mentioned?
183. Oh no.
Which it? What's that?
That's Michelle, I think. 183, but that's okay.
But yes, for 186, I covered that one. Yep.
I think I'd like to skip over 186 for today, and we'll just do our final discussion and vote on 183. So I think we're good on 186 for today. There were a couple other things I wanted to look at, but I think we are going to vote on 183. But that's Michelle's. So,
Right.
so I think we're all set, Eric. Thank you very much for all your help.
You're welcome. Glad to help, and I know I'll see you tomorrow morning for. I think 186 is on the agenda for tomorrow morning as well.
Voted up. Okay. Well, either way. Thank you.
Yeah, either way. Right. Okay. All right. Thank you.
Question for you, where we landed on 186, because I thought we were still discussing whether it was going to go to that task force or be what we were going to do.
Yeah, that's the thing that I'm trying to do.
Oh, okay.
So that's
Okay.
why I'm skipping over it for now. 183. Let's give me a second. So we are still live, just so you all know. I need to turn it off just to switch. All right. Senator Norris, is it version 2.1? That is the final version? 183.
I get copies for you.
183.
Yeah,
Let's go off live for 5 minutes. We're gonna go off live for 5 minutes and just reconfigure to get our final version of what